You finally got that big offer you're waiting for patiently all this while. But then comes the big question. When can you join? You mentioned 30 days to the hiring manager, but you just checked your appointment letter. Your official notice period is 90 days. Now, this is a painful situation to be in, not just for you, but also for the hiring company. 90 days is just too long. It's like you're in a toxic long distance relationship with your boss for 3 whole months. And here's a $1 million question. Is a notice period actually mandatory by law? Today, I'm going to decode the notice period, the history, the laws, and why you're stuck serving 90 days while your replacement hasn't even been born yet. But first, let's bust a myth. There's no supreme law in India that says serve 90 days or go to jail. Notice periods are not universally mandatory. They're contractual. Here's a fun trivia. In British India, your notice period depended on exactly one thing: how powerful your employer was. No labor protection, no rights. The employer woke up and said, "You're fired." And that was the HR policy. However, things changed after independence, and thank God for that. Enter the Industrial Disputes Act of 1947. For the first time, India said, "Boss, you cannot just throw workers out like that." Termination now required notice or salary in lieu. That's 1 full month. Suddenly, firing people became expensive. And that was further solidified after the Western India Automobile Association case in 1949. This is where judges declared that employment is not just a private contract, as it affects society. From then on, office fights became a public issue. Then, in 1958, the Honorable Supreme Court clarified three things in the S.S. Shetty versus the Bharat Nidhi Limited case. Notice periods must be written clearly. It must be exercised in good faith. And basically, firing someone randomly is not cool. By the 1960s and 70s, India went full labor welfare mode. The Standing Orders Act made companies write down termination rules properly. Notice periods became standardized in organized sectors. The courts leaned heavily towards employee security. Fast forward to the 1990s and the IT boom. Suddenly, everyone wasn't a workman anymore. We became managers, consultants, and senior vice presidents of nothing. Since white-collar professionals like us often fall outside the legal definition of a workman, the Industrial Disputes Act does not apply to us. So what rules us now? Well, the offer letter you signed. You signed it, you serve it. Around the 2000s, notice period jumped from 30 days to 60, and now the dreaded 90 days. But why? Just two words: knowledge transfer. Companies argue that specialized skills like knowing how to fix the server that only crashes on Tuesdays are hard to replace. They need time to find a new you. Businesses became knowledge driven. ERP, Workday, client, systems, data. You cannot replace people in 2 weeks anymore. Staying 3 months has become a must have for most leadership roles. They leverage your full and final settlement and the very important relieving letter. However, this has become a double-edged sword. A disengaged employee hanging around for 3 months can actually kill team morale. It's like keeping an ex-boyfriend in your house for 3 months after you broke up. Awkward, right? But there's a workaround. Employees can sometimes buy their way out. It's called salary in lieu of notice. You pay them or they pay you and you leave immediately. So to summarize, notice periods are legal because you signed the contract. Hence, always read the terms and conditions in your offer letter. Notice period has now evolved from "you're fired" to "please stay for 3 months." And before I go, here is some food for thought. If you're serving 90 days right now, hang on there. You only have 86 lakh 40,000 seconds to go.